All right, welcome back. This is chapter 2. We're going to get into probable cause and reasonable suspicion. This is the bread and butter of law enforcement. The police basically, their number one amendment that they're going to that is going to guide them in their job, not the First Amendment, but the most important amendment for police is the Fourth Amendment to the U.S. Constitution. In fact, if you were in this class in person, you'd be required to recite the Fourth Amendment word for word, verbatim, from memory in front of the whole class. So I challenge you right now, go memorize the Fourth Amendment, come back and say it to your computer screen. Obviously, I'm joking, but it's kind of cool. Like if you get, I've been, had lawyers, say, hey, do you know anything about the Fourth Amendment? Kind of sarcastic. We can go back and forth sometimes when we're in the adversarial process. A matter of fact, I do, and I can recite the Fourth Amendment verbatim. I would do it right now, but you'd think, oh, I'm just reading it off the screen, so I'm not going to waste your time with it. But moving on. Probable cause and reasonable suspicion. From Maryland v. Pringle, 2003, the determination of probable cause, they use objectively reasonable police officer. You don't have to, they kind of switch from man of reasonable caution because the average citizen may not be trained in what to look for as far as criminal behavior. Just like if there are any veterans in the class or, law enforcement, so forth. They're trained to look for indicators of someone who might be armed. Like a person walking only swinging one arm, you think, oh, well, they might have something wrong with their arm, but sometimes that is an indicator that they're placing their hand on a weapon that's underneath their clothes, especially when you're wearing a trench coat, like even an AK-47 for in a possible urban environment. So those are some bulge under the clothing. Those are some of the things to look for. Look for things like Smurfs. We call them Smurfs. It's smurfing when someone goes to a pharmacy repeatedly and buys, pseudoephedrine over and over again. Well, they've since passed laws that make that much harder, but one way to do smurfing is to get multiple people in a vehicle and go to different pharmacies. You got to get a lot of people to do it and buy pseudoephedrine and don't exceed the maximum amount. In fact, I've actually went to buy pseudoephedrine before because I like it for my sinuses. I buy it about once every year, and there was a glitch in their system. They said, oh, you bought it like 10 times. Like, no, I haven't. I was actually still a state trooper at the time. I got a little nervous. Called narcotics, said, hey, I didn't buy a bunch of pseudoephedrine to make methamphetamine. But anyway, they fixed their system. They fixed their system on the spot. But it's harder to do now. That's why most your methamphetamine that is on the streets today is not made in trailers anymore or out in the woods somewhere. Now the Mexicans have picked it up and they're making it actually better quality and cheaper and easier to get. So that's just an example of passing a law that makes it that accomplishes the goal, which is, hey, let's stop these people from making meth, but an unintended consequence of we didn't get rid of our meth problem. We just got rid of the people making the meth in the United States, and so they, like I said, they're shipping it over. And when I first started law enforcement, I made a bust, and I got about 2 ounces of methamphetamine, and at the time that was a huge deal. And more recently, we're getting kilos like it's nothing. It's kind of like cocaine now. Okay, so anyway, what the point there was that the police officer can use his experience and training in determining probable cause, and all those probable cause basically comes down to this: are there sufficient articulable facts? You can say, oh, that guy looks suspicious or that girl looks suspicious, and we need more than that. We need articulable facts. Well, if someone looks suspicious, that's not a crime to look suspicious, but why does that person look suspicious? Well, we got a call about a school shooting, and it's July in Louisiana. It's 170,000 degrees outside, and he's wearing a large jacket and walking with one arm not swinging, indicating there could be a weapon. So we got a call of a possible crime, and we have articulable facts that I just described, which would justify an officer to go and make a detention. Now, let's say it's on a area where you're not allowed to carry weapons, such as schools, outside the vehicle, and the police officer walked up and said, hey, and stopped that person and found that they're carrying a fully automatic AK-47. That would be illegal carrying of weapons. Also, concealed carry of a weapon, automatic weapon without a special license of the FAA, not the FAA, but the ATF, you can't have that. So that's just an example of where you have reasonable suspicion, based on the articulable facts, not, oh, that guy just looks like he could be a shooter. That's not enough. You look for something that you can write down, articulable facts. Anyway, you go up, pat the guy down, find it, and that turns, your reasonable suspicion to make a detention, which with reasonable suspicion you can detain and you can frisk if you have reasonable suspicion that they're armed. And just because you can stop someone doesn't mean that you can pat them down for weapons. We have our law enforcement and citizens need to understand, or I don't want anybody touching me that without my permission. It's a big deal. So when somebody puts their hands on another human being, especially our government, they need to do that with the proper legal authority, and that requires reasonable suspicion. Without reasonable suspicion, that's technically a crime. It's a simple battery, and police officers are not allowed to do it. I have seen some confusion where police think, well, if I have reasonable suspicion to detain someone, I automatically can pat them down for weapons, and that's just not the case. For instance, you get a call that there's a white male with a blue shirt, and we'll say slightly, mostly ugly. Well, they're going to see Steve Thompson and say, yeah, he might be our guy that stole some Skittles from the local convenience store. So anyway, that would give the police reasonable suspicion to come up to me and say, you need to stop. We got to figure this out. We got to find out if you're the person who stole those Skittles from the convenience store around the corner. And a quick police investigation can find that out. They go over there and look at the surveillance footage, or get the store owner to come over and say, yeah, that's him or that's not him. But the fact that I shoplifted some Skittles, it's a nonviolent offense. Without something else, something articulable like a bulge underneath the clothing, a violent criminal history, something saying that that I might be armed, the police can't just put their hands on me and pat me down for weapons. That requires reasonable suspicion of a weapon, and that's it. And it can only be a pat down for weapons. It can't go any further than that. So a pat down of the outer clothing. All right. If you had to put a percentage on probable cause and reasonable suspicion, reasonable suspicion is, gives the right to make a detention and do a pat down if there's a suspicion of weapons. I would say 25%. Probable cause, which allows you to make an arrest, put people in handcuffs, back of the patrol car, transport them to the jail, and also or a search, a search of a house, a search of a car, a search of a backpack, that requires probable cause, and the percentage of that would be more like 51%. It is 51%, more likely than not surety that this person had committed the offense. Most police officers act on basically, try to make an arrest with proof beyond a reasonable doubt. For instance, if a police officer gets a call to Walmart, and this has happened to me several times, police show up at Walmart, you got a guy sitting in a chair detained by loss prevention. And the loss prevention guy says this guy stole whatever is merchandise is sitting in front of him, and then he hits play on a video camera or the surveillance footage, and it shows the guy sitting in the chair stealing it. Well, that's essentially should be proof beyond a reasonable doubt. So the arrest is made though with the minimum burden of proof of probable cause. So that's kind of how it works up. Usually it goes straight to probable cause, which allows for an arrest, but sometimes people are detained briefly and either let go or it develops into probable cause with reasonable suspicion. Probable cause is required for arrest with a warrant or arrest without a warrant. Most arrests are made without a warrant, about 95%. Probable cause is required for searches without a warrant and searches with a warrant. But the difference is when there is a warrant for an arrest or a search with an arrest warrant, the judge makes the determination of probable cause. When that's done without a warrant, a search or arrest, the police officer is the one who makes the determination of probable cause. And of course, I'm going to give you a caveat because usually this is the point where you're starting to get that question, well, how are all these searches happening without a warrant? Well, most of them happen with consent, but understand something. When a citizen says, okay, you can search my property, my car, my house, whatever the case may be, without a warrant, they're choosing to take their Fourth Amendment rights and waive them. Say, here, I don't need them, and throw their constitutional rights out the window, at least until that particular search is over. Now, with that said, when someone does grant consent, they can revoke that consent at any time. I've covered that. Now, if a warrant is obtained, if there's a lawsuit, it kind of places the the liability on the judge, and that's kind of a false statement because judges pretty much have complete immunity from lawsuits. So if a police officer wants to protect himself or herself from civil liability, and they're not just not sure about what's going on with it, go get a warrant. In fact, I worked plain clothes, and I did a lot of cases, big cases, and if they were not a flight risk, if they showed no signs of possible violence or anything, and I thought they might, it would be easy to find them once I let them go after an interrogation and I had developed probable cause, I made it a point I would let them go and then just go get a warrant. It actually looks pretty good when in court we'll say, when you treat somebody we'll say with respect, they come in and the first thing you say in an interrogation is, hey, I'm doing an investigation, you're a suspect, I want to talk to you about this, get your side of the story. Give them their Miranda rights. Tell them, hey, when this is over today, you're leaving. You're not going to be arrested. They may say, well, am I going to be arrested later? Well, that's possible. And when I say you're not going to be arrested, I say I'm going to continue this investigation, and there may be an arrest later, but you're not getting arrested today. So, of course, get a valid waiver of Miranda rights. They are allowed to leave, and after possibly a confession for a pretty serious crime, sometimes hundreds of thousands of dollars, and then present all the evidence and articulable facts in an affidavit to a judge, and go pick them up later. Usually you can just call the attorney and say, hey, come on in. That's one of the ways to do it, but getting a warrant is always best to avoid civil liability. Here's a sneaky part of it. So the police don't actually have to, they can suspect somebody for something, and I'm sure all of you have heard there's more than one way to skin a cat. If they look at, let's say they look at somebody and think, you know what, here's an example I like to give. I think that guy might have a gun, and he's a convicted felon. Well, just because you think somebody might have a gun and you know that he's a convicted felon, that's not probable cause. You can't write an affidavit just to give to a judge, and the judge should look at it and say, no, this is not going to work. You can't say the hair on the back of my neck is standing up, and I just think this guy's got a gun. It's just a gut feeling. I wish we could, or I don't wish we could search on that, because we'd be back in the days of the general warrant before we even had constitutional rights. But if a police officer can actually look for a gun, if under the right circumstances, by going, we'll say, a different route. So let's say this guy is a marijuana user in the state of Louisiana. Marijuana is illegal still. Pull the guy over for a traffic violation, a valid traffic violation, like failure to use a turn signal, speeding, improper lane use, one headlight out, whatever the case may be. The guy gets pulled over, and the police go up to the vehicle and smell the odor of marijuana. That officer may not even care about marijuana, may not even want to deal with marijuana, but he wants to search that car for a gun. At that point, even though he has no probable cause to search that car for a weapon, he can search that vehicle for a gun. But he has no legal justification. The legal justification is he has probable cause to believe that there's illegal drugs present in the vehicle. Anywhere there could be drugs, there could be a weapon, therefore his subjective intent, dirty mind we'll call it, being sneaky, more than one way to skin a cat, can actually search for that legally. And that's what our courts have said. It doesn't have to be inadvertent. They've removed the inadvertence requirement, as long as what the officer does is objectively reasonable. Is what the officer doing legal? And that could be looked at. That's why one of the reasons why it's kind of hard always, or most of the time, to identify bias policing. Like if an officer sits and only stops people of color, that's legal. Because I say it's legal, it's discrimination, but let's say they only stops people of color for window tint violations. Well, different races have, or white people have blacked out windows that are illegal, people of color have blacked out windows that are illegal. So, but if the officer only stops people of color, that's racially biased policing, but although if you look at each stop individually, it's technically legal. Not ethical, but it's technically legal because, it's visually obvious that someone has illegally tinted windows. So, but that's one of the reasons why it's hard to identify. You know, it takes research like the DWB project that was done, I believe, on the New Jersey Turnpike, where they did prove or find statistically significant evidence that people of color were being stopped more for speeding than people who were not of color, even though they sped at essentially they were committed the violation at a very similar rate. They were stopped more, they were cited more, they were searched more, and they were arrested more. So that was the statistical result. So, you know, it's hard to prove. So what the officer's intent, and I'll tell you as a police officer, I've done this many times. You know, when I led the state police for all 4 years in the Southwest Louisiana in DWI enforcement that I was on patrol. I didn't do that because I was lucky. I did that because I essentially profiled, criminal profiling, we'll say. One of the ways I would criminally profile, not to be confused with racially profiling, was to identify vehicles that were more likely to be operated by an impaired driver. One of my favorite ways to do that was just run license plates. Every vehicle that drove by, I'd run the license plate and see that the driver's driving history would come back just like that. And when I saw a driver that went by that had no history whatsoever that come up on my system, I didn't do anything. But when I saw one that came by that had a suspended, the owner had a suspended license. I didn't know who was driving the vehicle. You want to assume that the owner is the operator, but that may or may not be the case. So let's say the vehicle drove by and the owner had a history of a DWI, even a valid license. Well, I don't know who's driving it, but I think it might be the owner. Can't stop based on that because, what did they do wrong other than do something in the past for which they've already paid for? They already paid their fines. Their license has been if it was suspended, it's valid again. So anyway, I'd follow that vehicle, and I wanted to stop the vehicle to see if the driver was drunk. But again, I had no probable cause to believe that the driver was drunk. But if I saw a traffic violation, any traffic violation, the license plate lied out, failure to signal, driving off the side of the road, drifting left of the center line, running a red light, speeding, whatever it was. And most of the time, drunk drivers would give you that. Anyway, if I found a traffic violation, I would stop the vehicle. I didn't care about the traffic violation. Most of the time when I'd stop them and they were not impaired, let them go. No ticket, no anything. But more likely than not, they were drunk. And so that's how I was able to get a lot of drunk drivers. I call that criminal profiling. And based on the prior history of the registered owner, usually the owner was a driver, and I get a lot of drunk drivers that way. Again, criminal profiling, not to be confused with racial profiling. Look, if you can't criminally profile, you can't be a good police officer. If you're looking for a serial killer, typically you're going to be looking for a white male. That's part of the criminal profile. That's what the FBI does. If you're looking for a crime that was committed in trying to think. If you're looking for a guy who embezzled $100 million, you got to go to the bank that the person works at or the suspect works at. Anyway, again, we call that criminal profiling. All right. The police have to establish probable cause before they take any action. If probable cause is discovered after that, what happens is everything they found up until that point, it falls under the exclusionary rule. It's not able to be used in court. So, just for instance. One of the examples I like to give to the police officers is, so let's say you roll up to a traffic light, and I'll turn my chair this way just so you can see. You roll up to a traffic light and you see a driver like me sitting in my car, and I'm stopped. And then the police officer pulls up next to me, and I look over and go, oh crap, it's the cops, and I reach up and grab my seatbelt and put it on. Because I don't want to get a seatbelt ticket. It's illegal in Louisiana to, they say you got to wear your seatbelt. So the police officer looks over and sees me put on my seatbelt. Light turns green, I take off. Police officer writes a report, and there's a dead 9-year-old girl in the trunk of my car. Okay, so this is the greatest thing that this cop could have ever done. He got a child killer off the streets. He writes a report. Exactly what just happened. He was driving down the road, pulled up to a red light, saw me stopped at an intersection. My seatbelt was not on. I put my seatbelt on, and then I took off in forward motion. The defense attorney is going to say there was no probable cause to make that stop. And, of course, the prosecution will argue, well, there was probable cause not to find a 9-year-old girl that was, dead in the back seat, but to stop for the traffic violation of Louisiana Revised Statute 32295.1, failure to wear a seatbelt. But if you study the elements of that offense, you'll see that to violate that statute, you must be in forward motion. So if someone's sitting in a red light, they're actually legally allowed to take their seatbelt off as long as they put it back on before they move forward an inch. If they move forward an inch, they violated the statute on a public roadway. So therefore, that's an example of there not being probable cause of a violation resulting in finding some, probable cause to arrest dead 9-year-old kid in the back, where everything that was found up till that point can't be used against him. So technically, that case, all the evidence involving that dead child that was found in the car and tying it to the suspect who was driving would actually be thrown out. All right. Officers can use basically any trustworthy information. The like hearsay in court, rules in court don't apply to police investigations. For example, I've worked cases where witnesses have told me, hey, I heard so-and-so was dealing drugs, or I think so-and-so is dealing drugs. And that's not necessarily, I heard it is not really direct evidence, but I can use that information. I can write it down in an affidavit as long as I've got something else in addition to that, to justify making an arrest or establishing probable cause. For instance, I got, we'll say, a somewhat anonymous complaint that a guy was a bookmaker, which is a bookie, so taking illegal sports betting and making money off of it. And that was definitely not a probable cause. But what I ended up doing was, let me try to corroborate that information. So the way I corroborated is I went through his trash for 6 months. Every Wednesday night, I believe it was, I would go and take his trash that he put by the road at 2 o'clock in the morning. I would go at 2 o'clock in the morning. I don't know when he put it out there. Take it somewhere, go through it, get criminal evidence, and then put it back. Because if you take your trash to the road, you're abandoning that property, and therefore anybody can come get it, so including the police, and they can use it against you in court. So anyway, that was an example of not really reliable information, but it was anonymous information that I corroborated and turned it into trustworthy and reliable information. There's in an affidavit for an arrest or for a warrant, what must go in that affidavit is articulable facts. So let's make sure we understand the difference between articulable facts and a conclusionary statement. A conclusionary statement would be something like, he looks suspicious. Oh, okay, great. We'll go stop him, arrest him, whatever. He just looks like somebody who committed this crime. Write that down in an affidavit. That's not going to cut it. Okay, so we need articulable facts. Why does he look suspicious? What happened? So conclusionary statements in court are not allowed except by expert witnesses. I am an expert witness. I can testify to issues involving use of force and impairment. So like I help prosecutors prosecute people for drunk driving, or even sometimes I'll help the defense when the person was not drunk driving is being prosecuted. I'll help them, the defendant, I'll provide evidence that the police officer, was mistaken in making a DWI arrest. So, but it must be articulable facts. You can say, I guess the best example I can give is, okay, I stopped the driver and the driver was drunk. Well, the driver was drunk is actually a conclusionary statement. What needs to be said is the driver was swaying front to back. It's something that I can visually see and write down in a report. The driver's breath had a strong odor of an alcoholic beverage. That's another articulable fact. The driver's speech was slurred. The driver was administered a standardized field sobriety test, and he exhibited, 6 clues or 8 clues or whatever the case may be. Those are articulable facts. Now, that should lead the reader, and the police officer and the judge, jury, so forth and so on, to conclude that the person was too drunk to be driving. But again, in an affidavit, we need articulable facts versus conclusionary statements. 3 ways to establish probable cause. The officer's own knowledge of particular facts and circumstances, what the officer sees. Information given by a reliable person, a third person, an informant. And establishing reliability is a whole nother ballgame. But if you have a traffic crash where one person says they ran the red light, and the other person says they didn't, your witnesses, if you got a third car that doesn't know either party, that would be more of a reliable source than the person, in the car with the other driver who has, possible friendships that would call into question their reliability. And then lastly, information plus corroboration. So even anonymous information, or I heard this might be happening. In corroboration, like for instance, me going through the trash, or following up with witnesses, so forth and so on. So, Those are the three ways: officer's own knowledge, reliable informants, and information plus corroboration. Just to cover, I can cover this real quick. Tracking devices that might be put on vehicles. We used to be able to put those on without a warrant or anything like that. We can't do that anymore. So if a tracking device is going to be put on a vehicle to see it, where it goes and log where it goes, then that can be done without a warrant. And there's really no point in putting tracking devices on vehicles anymore, because you the vehicle either has OnStar or everybody has a phone that you can track through the phone company with a warrant, of course. So the police are not allowed to track you without a warrant. Most people out there are tracking themselves on Facebook anyway, checking into this gym or restaurant or whatever. But, okay. There's a question here, which is arresting passengers of motor vehicles. So, it's a trick question that I kind of give out, and I like this better in the classroom. But the question is, if you have probable cause to arrest the driver, do you have probable cause to arrest the passengers of a motor vehicle? And I'll give it away. It's really simple. It's not really a trick question. It's just simply obvious. Every single person that is going to be arrested, that person must be arrested with probable cause. There must be sufficient articulable facts leading a reasonable person to believe, reasonable officer to believe, that that person committed a crime, and that's it. So if you stop a driver for drunk driving and there's a guy sitting in the back seat, well, the guy sitting in the back seat did not violate the statute of Louisiana Revised Statute 1498, driving under the influence of alcohol. But the driver sitting in the driver's seat did. Now, let's say you got a strong odor of marijuana in the car, and there's 40 pounds of marijuana in the trunk of the car. Okay, well, you could say that you have probable cause to believe that, we'll say there's 3 occupants in the vehicle. You have probable cause to believe that they are all knowingly in possession of the 40 pounds of marijuana in the back of the car. A quick war story: we actually seized 40 pounds of hydroponic marijuana one time, and we were driving into the evidence locker in an undercover vehicle with, it was a white Chevy Trailblazer with blacked out windows, 24-inch rims, a very loud sound system, and let's say, and an expired inspection sticker. So the police stopped us for the expired inspection sticker, and anyway, we pulled over, and there was 40 pounds of marijuana sitting on the back seat. And I politely told them, "Hey, by the way, there's 40 pounds of weed on the back seat." We were okay. We continued we went and processed. We put 20 pounds into evidence. If you caught that, we kept the other 20 pounds. No, we put it all into evidence. But I've been actually stopped by the police, who didn't know that they were stopping other police with 40 pounds of marijuana in the back of the vehicle. Okay. Make sure we cover reasonable suspicion and probable cause. So probable cause says you can search or you can arrest. Now, they're not one and the same. Just because you have probable cause to arrest someone doesn't mean you have probable cause to search their house or their car or anything like that. You pull me over for speeding, and then you run my license and see that I've got a warrant for not paying a seatbelt ticket. Well, there's no probable cause to search my car. You got probable cause to arrest me for the warrant, but again, there's no probable cause for search. Reasonable suspicion, the same thing. Reasonable suspicion allows an officer to detain someone and pat them down, but they're two separate events. Or they require two separate sets of facts, we'll say. So if I'm stopped for suspicion of stealing a bag of Skittles, you don't know it's me yet, you can't pat me down for weapons, because you have no articulable facts that I've in possession of a weapon during that lawful detention. But let's say the call is a bank robbery with weapons. Then you see me fitting the description of one of the bank robbers. I'm going to get pulled over, and they're going to be allowed to detain me. And it would be okay to put me in handcuffs until they figure it out and pat me down for weapons. But let's say they pat me down for weapons and they don't find a weapon. And they say, "Where are you coming from?" And I say, "I was at the gym and I'm on my way home," and I'm calm, I'm cool, there's nothing wrong. Well, let's say, so there's no probable cause to arrest me, at least yet. And then they get a call from the other side of town or a few blocks away. Says, "Hey, we stopped another car and we got the suspect here. He's got the money, he's got an AK-47, and we're making the arrest right now." Well, those officers that are out with me at that point, they had reasonable suspicion to detain me, and I didn't do anything wrong, but it's still a lawful detention. And if I resist that detention, I can actually be arrested for resisting an officer. So with that said, at that point, once they establish that I did not commit a crime, and I'm no longer under suspicion of committing a crime, they're going to have to let me go. So, that should be how it goes. But again, reasonable suspicion is a less demanding burden of proof than probable cause. Reasonable suspicion allows a detention and a pat down for weapons if there are articulable facts leading a reasonable officer to believe that the person is armed. There's got to be something. Violent criminal history, bulge under the clothing, reaching into the pockets repeatedly, possibly trying to access a knife or whatever, on a lawful detention. Even in Louisiana, it's not illegal to carry a weapon, concealed or otherwise, as long as the person has a concealed handgun permit or a pocket knife. Pocket knives are generally not illegal. A lot of people carry them. But on a lawful detention, a police officer is allowed to briefly disarm that person in the interest of, and the court support that in the interest of officer safety. Once the detention is over, and those weapons are possessed legally, they are returned, and the person's free to go on their way. Okay. All right. What is looked at? I wish I could tell you that there was just a perfect set of rules for determining reasonable suspicion and probable cause, but I'm sorry, there's not. There's so many possible circumstances out there, it's just impossible. So we got this vague rule that says whether it's okay or not. You take into consideration the totality of the circumstances. The totality of the circumstances for reasonable suspicion to make a detention, the totality of the circumstances to pat someone down, and the same thing for for arresting someone or searching their house, property, whatever the case may be. Totality of the circumstances is the general rule. The Supreme Court doesn't like to tie things down to an exact science, and there's no way to, because there's too many. There's an infinite number of possibilities that an officer may face. Some crimes are pretty straightforward, like we'll say a DWI. That was my specialty when I was on patrol. And I might, I administered a lot of field sobriety tests that resulted in people failing it, and I made the arrest based on the failure of the standardized field sobriety test. You look at the totality of the circumstances, and that was it. But sometimes people either could not take the test because of physical impairment or injury, or would not take the test because they've been arrested 16 times for DWI. So maybe I only had, the swaying front to back and slurred speech, or maybe they won't even talk, or maybe I have the strong odor of alcoholic beverage on breath, I have the driving behavior. You put it all together, and it may or may not equate to probable cause. Just depends on the circumstances. I've had people refuse to answer any questions whatsoever, just sit in the car and refuse to get out. They were drunk, and they knew that they were drunk, and they knew any cooperation could be used against them. And I've seen a conviction based on that as well. So again, if you're studying for the test and you see totality of the circumstances as an option, it's probably the right answer. All right, that wraps up Chapter 3 really quickly on reasonable suspicion and probable cause. And I know I'm beating a dead horse, but I'm going to say it one more time. Reasonable suspicion allows for a detention and a pat down for weapons if there's suspicion of a weapon. Probable cause allows for a search and allows for an arrest. It's a higher burden of proof. If you have to put a percentage on it, reasonable suspicion, 25% surety that they did it, and probable cause, 51%. More likely than not. That's the standard. All right, see you in Chapter 4.